First, I just wanted to welcome all of you here today. My name is Erin Corcoran, and I'm the Executive Director of the Warren B. Rudman Center for Justice, Leadership, and Public Policy. And this center just opened up this spring, but for those of you who are here from the class of '78, you all know that this center is building on UNH's historic commitment to public service. And part of what this center will do is to continue to fund students during the summer who are doing work in government service or the public interest. Taking the place of the PIC Fellows will be the Rudman Summer Fellows. We have an inaugural class of 15 this summer. It'll be placed all around the country, ranging from the Philadelphia Public Defender's Office to the Attorney General's Office of New Hampshire, Catholic Charities, the Federal Trade Commission in Washington, D.C., the Federal Public Defender for the Western District of Texas are just a couple examples of where the students will be at this summer. And so I just wanted to let you know a little bit about that. And today we're really honored here to have our commencement speakers who have been here in New Hampshire since yesterday to have a more intimate discussion about some of the issues that they've been working on. And here to moderate today's discussion is Professor John Greabe. Before joining UNH Law faculty full-time, he was a professor at Vermont Law School, and he teaches quite a lot of different subject matters. He teaches constitutional law, civil procedure, federal courts, civil rights, conflicts of law, and as a member of the faculty, I feel really fortunate to have him here at this school. He's been a tremendous asset for us. And he got his BA from Dartmouth and his JD from Harvard. So he's also he's also been really involved in this program called Constitutionally Speaking, which for those of you who haven't heard about it, it's a statewide initiative to engage New Hampshire, the entire population across age ranges, in a spirited and civil dialogue about important constitutional issues of our time. And so one of the events was actually last night at the Capitol Center for the Arts, in which David Boies and Ted Olson talked about the work that they've been doing with their Proposition 8 case, and Laura Conoy from NHPR moderated that discussion. The event was launched last year with Justice Souter. So we've been doing, and the law school is one of the sponsors of this event. So we're really fortunate that John Greabe's been a part of the planning and implementation of this great initiative. Okay, just wanted to give you a little bit on the format of today's program, and then we'll get started. You'll notice there's note cards scattered throughout the table. So this is meant to be a conversation, and so if you guys, to the extent you have questions that you want to ask our speakers, please feel free to write those questions down and pass them to the aisleways, and I'll be circulating throughout the room and picking those up. And then from there, John Greabe is going to introduce our speakers, and then he'll start off asking a few questions to get the conversation started. But really, we want this to be an opportunity for all of you to ask questions of these incredible lawyers that we're really fortunate here to have today. So thank you very much. And John, I'm going to turn it over to you.
Thank you very much, Erin. Time is short. As I was looking at your biographies online, I thought, well, I could take up about 45 minutes of our time just talking about your careers. And my understanding is that there'll be a more fulsome introduction made at the commencement ceremony today, where I believe everybody in the audience will attend. So just a couple of highlights. We're so pleased and fortunate to welcome attorneys David Boies and Ted Olson to UNH Law. Last night, as Erin mentioned, was just an absolutely fantastic event. Mr. Boies founded the law firm Boies, Schiller, and Flexner in 1997. Prior to that, he was a partner at the New York law firm of Cravath, Swaine, and Moore for many years. In 2010, Time magazine said that Attorney Boies was one of the 100 most influential people in the world. He has been chief counsel to the U.S. Senate Judiciary Committee and the Senate Antitrust Subcommittee. Among the famous cases, and I could go on, but among the famous cases, of course, Bush versus Gore, the U.S. versus Microsoft trial that was tried now over a decade ago, the Napster litigation. Mr. Boies has received numerous awards and honors. He is a graduate of Northwestern University and has law degrees from Yale and NYU. Attorney Ted Olson is a partner at the firm of Gibson, Dunn & Crutcher. He has been with Gibson, Dunn & Crutcher since 1965 with two noteworthy absences from 2001 to 2004. Attorney Olson served as the Solicitor General of the United States under George W. Bush. He also served as the Assistant Attorney General in charge of the Office of Legal Counsel in 1981 through 1984 to President Ronald Reagan. Attorney Olson has argued 59 Supreme Court cases, including such noteworthy cases as the Bush versus Gore cases, the Citizens United case, of course, the Proposition 8 case that we're all awaiting the decision on. Attorney Olson is a graduate of the University of the Pacific, undergraduate, and has his law degree from Berkeley. So with that as background, I thought that I would start today by asking you, last night we talked a lot about the Proposition 8 case, and I thought I'd start by expanding the lens of focus a little bit and ask you a little bit about the court that's being asked to decide the Proposition 8 case. Chief Justice Roberts was appointed to the court in 2005, so we're coming up to the end of his 8th term. And during his confirmation hearings, Chief Justice Roberts self-identified as sympathetic to the legal process school of thought, which would say that generally courts should be modest, should defer to democratic majorities, should be attentive about not getting too far out in front of the public. And one of the questions you were asked last night was, in the Prop 8 case, are you asking the court to get too far out in front of the public? So my first question is just specifically with respect to the Prop 8 case, how do you explain to a justice who is inclined towards the legal process position that a ruling in your favor is warranted in this case now in 2013? Last night, Laura started with Mr. Olson. So why don't I start with Mr. Boies and then turn to you?
Yeah, I'll find out what the answer is.
I think there are 3 responses to that. First, we're not asking the court to create a new constitutional right. This is not a situation like, for example, Roe v. Wade or other cases in which the court has articulated new constitutional rights. This is a case in which the basic right at issue, the right to marry, has been well established over and over again by the United States Supreme Court over the last 100 years. You've had state after state that has tried to restrict the right to marry. Of course, you had Virginia and 16 other states that in the 1960s, middle 1960s, limited marriage to people of the same race. The United States Supreme Court held in Loving against Virginia that was unconstitutional because people had a fundamental right to marry the person that they loved. You had a case in Wisconsin where Wisconsin had a law that said if you abuse one marriage, you don't get a second try, you don't get another marriage license. You're behind in your child support, you can't get another marriage license. Perfectly rational approach. But the Supreme Court said, yes, it's rational, but marriage is such a fundamental right. It's so inherent in the right to liberty and the pursuit of happiness that even for good reasons, you can't restrict that. Missouri had a law that said imprisoned felons can't get married. And the people defending that law said, well, the purpose of marriage is propagation, and they can't propagate in prison, and so you ought not to let these people get married. And of course, you take away all sorts of civil rights of people. Take away the right to vote when you're convicted of a felony. But the Supreme Court said, even though you take away basic rights of citizenship for conviction of a felony, you can't take away the right to marry because it is so fundamental. So I think the first thing is that this is not a situation in which the court is creating a new right. The second thing I would say to the court is that whenever the court enforces constitutional rights, it is by definition overruling a majority vote. If the majority votes in favor of the constitutional right, you don't need the court. And indeed, if you were always going to go with a majority, you wouldn't need a written constitution. The reason we have a Bill of Rights, the reason we have a written constitution, the reason we have a Supreme Court that's given the power to enforce those is because there are certain rights that are so fundamental that we believe that no majority, no matter how large, ought to be able to take them away. The third thing I would say, but probably not in an argument, but if this came up in informal conversation, is that the court isn't ahead of the people. The court's lagging a little bit here. If you look at the polls, substantially more than half of all Americans believe in marriage equality. And over 80% of the people 30 and under believe in marriage equality. Now contrast that with a situation in 1967 when the court was confronted with Loving against Virginia. At that point, 64% of the American people opposed interracial marriage. And yet the Supreme Court said that's so fundamental, that it's such a fundamental right that it has to be enforced. And remember, when the Supreme Court outlawed segregation, they had to send troops to desegregate the schools. This was a situation in which the court in that case was way far ahead of where the people here are. So I don't think the court is actually ahead of the people, but I think even if it were, that's exactly what the court's supposed to do when fundamental rights are infringed.
Thank you. Mr. Olson?
I'll just add a sentence or two. I think David hit it right at the end. We were asked that same question essentially in the trial court. The district judge raised that issue. And I basically said in more elegant words, I hope, that's your job. That's your job. When the individuals came to us because they felt that their constitutional rights to marry and to be treated equally under the Constitution had been taken away from them by the voters of California, they asked us whether we thought they had a right that was to be vindicated by the Constitution. And they asked us, what do we do about it? And our answer was, you go to court. That's why we have a court, and that's why we have the Constitution. That's very fundamental.
And just picking up on that point, would it be fair to say, in your estimation, that notwithstanding the legal process-based presentation that was made, that the Roberts Court has not been shy about recognizing constitutional rights, even in circumstances where Democratic majorities, large Democratic majorities sometimes were opposed to the recognition of their rights?
Absolutely. I think it's interesting that there were, for 12 years running, there was no appointments to the Supreme Court, which was about the longest time in history that we'd had one justice be the junior justice. Justice Breyer was telling me that he got a little tired of being the one that had to get the coffee. But in the last 4 years we've had, or last 7 years, we had 4 new appointments to the Supreme Court. And notwithstanding what happens in confirmation hearings, the job in the confirmation hearings is to have the oxygen sucked up by the senators' questions, and they tell the candidates when you go in for the confirmation process, if there's more time consumed by the questions by the senators or statements in the form of questions then you speak, then you're going to be confirmed. So all the judges go in and say, we're going to be modest, and we're going to be this, and of course you say all those things, right. And they do. And it is a court that respects the will of the majority and the democratic process. But at the end of the day, when you're on that court, then you have your conscience and you have life tenure, and all of these justices are very sensitive to the fact that they have a responsibility to the Constitution, an enduring responsibility to the people that brought this Constitution into existence and the people that are coming in the future to respect and preserve that Constitution. And the Roberts Court and all of those justices take their jobs very seriously. But if it's necessary, they'll do what it takes. Mm-hmm. Now, with this case, it's complicated because there's various different ways in which the Supreme Court could come out, and I won't get into that. Right. But there's jurisdictional issues and that sort of thing. Yeah. And the court might well decide, we don't know, that the court might well decide that, well, we don't want to bite off as much as we could. On the other hand, the justices might decide this is fundamental and we have to go exactly to the core of things and overcome the jurisdictional problems. We'll see.
Right, and there's another case also that could at least exert a gravitational pull on the ruling of this case, and which opens additional doors.
Yes, as you all know, the court heard the argument in the Proposition 8 case on March 27th, on March 28th. The court heard the arguments in the federal defense of marriage case, which restricts the rights of individuals in places like New Hampshire or New York, or as of this last weekend, Minnesota, that grant individuals the right to get married, and then yet the federal government won't respect their rights. And that's a very, very important case.
I anticipate that there'll be plenty of questions coming up. I'm going to move off of Prop 8 and just ask you one more question, and it's related to a point that was made last night. The question was raised last night, or the statement was made last night, that we're in a period of hyper-partisanship and extreme dysfunction. And you made the point, and I always try to make this point with my students as well, is it always seems to the present like things are bleakest right now, but when you really look back through history, there have been plenty of pretty bleak times, politically speaking. But all of that said, to the extent that there's some truth to the argument that we're experiencing high degrees of deadlock, you attributed it to, or at least in part, to redistricting and the fact that we now have the mechanism and the means for drawing legislative boundaries in such a way as to protect incumbents, and that there are very, very few seats, particularly in the House of Representatives at the federal level, that are truly in danger. Is there a role for the court? Now, under present doctrine, any sort of equal protection claim or constitutional claim against such partisan redistricting is treated as a political question. The court has said there are no standards we can use to get involved and reform in this area. Do you think, would it be proper, to ask both of you, would it be proper for the court to perhaps revisit that question in light of what we're seeing?
The last one that I remember that was a case involved Pennsylvania, and the court came out, I think it was like 4-1-4 or 5-4, something like that, and it was partisan gerrymandering. Is there too much politics in redistricting? And I can't remember, I think it was Chief Justice Rehnquist who wrote that decision, but I could be completely wrong about that. But well, I think one of the justices at least says partisan redistricting, that's what it is. I mean, that's politics, and that's what people get to do. And the majority in that case, there was a very powerful several dissenting opinions, as I recall, and the majority in that case went through each of the arguments that would be made to support a court role in saying that the politicians had been too political, and essentially dismissed them and saying, we can't do that, we can't get into that. And the more the courts do it, the more the courts become part of the political process, and that's maybe become too much of the way it is anyway as a result of the confirmation hearings. But it seems to me that however unfortunate the consequences might be with respect to some of the redistricting that takes place in states where you have people that are in 70% districts, they're not interested in the other side. And when they go to Congress, they're interested in pleasing those people that they know they're going to return them to office. But nonetheless, I think that the judges should stay out of it. That's just my opinion.
Right, thank you. Mr. Boies, would you like to speak to that?
I think I basically agree with Ted. I think that it is a serious problem. It's probably a problem that the court is going to stay out of, although Ted and I are old enough to remember when the court said that how many people were in a district was a political question before Baker against Carr. And so I think that the court has been more willing to wade into some of these political questions. I think they're more willing to wade in if it looks like the gerrymandering is affecting a racial division, something like that. But just on terms of politics, it's so hard to figure out, as you say, when is a politician being too political? So I suspect the court's going to tread very, very carefully in that area, and should.
Great, well, thank you. I've received some questions from the audience, so I will relay these along.
We don't get to look at the questions. Oh, sure. Yeah. I meant read them. Right. He just showed us the questions. We don't get that in the Supreme Court.
Exactly right.
We don't even get to see them.
Well, I hope this is a fair question. When you talk to each other frankly about the Supreme Court ruling in Bush versus Gore, what do you say?
About what we said in court.
We watched. We were together. Some of you saw this movie that I guess was HBO that did the movie, A Recount, which was supposedly a documentary showing this thing. It was done.
Fair and balanced.
All the people on his side were involved in making the movie. So we went.
Baker loved it.
Yeah, well, yeah, plus Jim Baker. But so they gave him a nice role, and then someone said, "Who played you?" And I said, "I don't remember me being in that movie." So we went. Mary, you were there, weren't you, Mary?
Right, yeah.
We went to the premiere of that movie. It was the home of Ben Bradley and Sally Quinn in Washington, D.C. A senior editor of the Washington Post. You all know who Ben Bradley is. And so they premiered the movie, and the actors were there, and the director was there, and the writer was there, and so forth. And we had a little reception where we drank some wine. Then we had a dinner where the movie was going on. And I kept, every time I saw something that I thought, that I don't remember it happening, I'd go up to the bar and get another drink. Finally, about 2/3 of the way through it, I told my wife, I said, I can't stand this anymore. I'm getting out of here. So not long after that, 2-3 weeks later or a month later, we were together on a bicycle trip in France. And I said, David, I didn't stay for the end of the movie. How did it come out? And he says, I won.
I remember that.
That's great. Thank you. Another question. Other than changes in personnel on the Supreme Court, what changes, if any, have you observed in the court over your years, your respective years appearing before the court?
You go ahead.
Well, one of the things that's very different is that the amount and number of questions. Justice, when I first argued in the court, I think my first argument was 1983. Justice Brennan didn't ask very many questions. Justice Marshall, once in a while, on a case that interested him, asked questions, but he didn't ask very many questions. You would go through the whole list, and very few of them asked questions. And I remember listening, you know, they have those broadcasts, NPR or C-SPAN or something does these things. And I remember Dean Griswold, when he was Solicitor General, arguing a case in the Supreme Court. It was like this big, massive steamship rolling through the seas, and then occasionally a question would come up, and he'd brush that aside. So now I think it started mostly with Justice Scalia, and then that era. Now you have, aside from Justice Thomas, who has his own reasons for very seldom, almost never asking a question, 8 of them are asking questions, and they're asking questions all of the time, and they're interrupting themselves. They're interrupting the advocate. I had an argument in this case. We ceded 10 minutes to the Solicitor General, so there was 20 minutes for our side. Our side was interrupted 46 times in 20 minutes with questions, and that's the same thing with almost every argument, every side, whether it's an ERISA case or whatever it is. I think that they feel that they've been locked up in this, this solitary confinement, and all of a sudden they don't talk to themselves very much. They've got this is red meat now for them. They're out there, they're going to have fun. They're going to eat up the lawyers who are standing right there in front of them. And so they're having, time, and they're arguing with one another. And I think that's one of the big things that I notice. There's also one more thing. When I first started, there were about 150 cases that the court took a year. Now it's about 75 cases the court's taking, and in the 30s it was 200 and some cases. So beginning with the Rehnquist court, the court started taking fewer and fewer cases. Now they have 9,000 petitions and 75 cases. So that's a big difference too.
Do you think that the more vigorous questioning and more frequent questioning is it tied at all to the question always is, have they made up their minds? Is oral argument really theatrics? Do you think it's a signal that perhaps less than before the justices are going into oral argument open to being persuaded, if not in terms of outcome, at least maybe direction or breadth of?
Well, I'll say a word or two, and then David will. We, as an advocate, you believe that everything is going to depend upon oral argument, and that, you have to believe that. You have to. We take it very seriously. Besides, it's a scary thing, getting up there in front of those justices. But so we always believe, and we go in with the conviction that everything that we might say, everything that we might do, every little mistake we might make could count. The justices will say that they have an open mind, and they will also say that they have changed their mind as a result of oral argument. And there's some famous examples. Justice Kennedy said in the Batson case, which was involved whether jurors could be excluded on the basis of the race and peremptory challenges during trial court proceedings, he was persuaded by the lawyer who said, what does it must feel like if you're a black person and you're excluded from a jury by a lawyer because of your race? He says that he was affected by the oral argument. And there are people that say that the conventional wisdom, you might not win a case during oral argument, but you can lose a case during argument. And I've seen some things during oral argument that make you think that maybe the guy wanted to lose.
No, I think that's right. I think that when you go in, you've got to go in believing that it's all critical. Otherwise, you won't be prepared adequately. I think that people do change their minds. I think particularly in cases that are complicated, where there are lots of alternative ways to resolve it, like the Perry case. I think people go in with positions. I think some of those positions are not going to be changed, but often those positions can be changed, and often if there are alternative ways of reaching it, a narrow way and a broad way, they can be convinced by the oral argument that maybe the broad way they haven't thought it through enough and they ought to decide it on a narrower ground. So I think it can have an effect, although it has become much more a debating society. I mean, you've got a lot more experience at it than I, but the first argument that I had was, I guess, 1986. And now that was one, unfortunately, that Marshall participated in a lot because he had a contrary view to where I was coming from. But by and large, they tried to listen. They asked a few pointed questions. They didn't debate with each other. Now, I mean, when I argued the class action case, the Halliburton case, they were just debating back and forth. And of course, in the voting rights extension case, and to some extent in Perry, they actually stopped asking questions and actually responded to a question from one of the other justices, which a few years ago would have been unheard of.
Yeah, there was an incident a couple years ago in which, not so far ago, that one of the justices said, Mr. So-and-so, what's your answer to this following question? And Justice Scalia or somebody else said, I think his answer to that question would be such and such. And the Chief Justice said, well, maybe we might like to hear from the Mr. So-and-so.
Right.
Here's a question of particular interest to our audience because he lives right up the road from us. What do you think Justice David Souter's legacy is going to be with respect to his tenure on the Supreme Court?
Well, Justice Souter is so well liked in Washington by his colleagues on the court, and he's so respected. There's lots of things that he did jurisprudentially, but I'll just say something about his personality, his style, his humility, his modesty as an individual. He was never, it seemed to me, and I think a lot of people would agree with this, affected by Washington and being when you're on the Supreme Court, you are an instant celebrity if you wish to be. He never had any interest in that. He was so conscientious, such a gracious, we talk about civility. He's the very emblem of civility. We talked about integrity last night, integrity, a class person. And I've told him several times since his retirement that we miss him in Washington. Not that he always was if I was arguing a case that had any kind of ideological connections, I wasn't always necessarily going to pick up that vote. But I think David and I have the same feeling about all of the justices. They're wonderful, conscientious people, and Justice Souter would ask very intelligent, very difficult questions. And you got a question from Justice Souter, you knew, he'd really thought it through, and you better have a really good answer. And I asked him about his retirement because he could still be there. And he said he thought it was the right time. And I think that you get, as a member of the Supreme Court, such an important person. It's 9 Supreme Courts in a way, and you might be in a position where you just don't realize that maybe it's the time to go. He wanted to leave before it was, people would say, you waited too long.
Yeah. I think there have been, and I think he probably thinks there have been people who have stayed too long on the court, and I think he was determined not to do that. I think his legacy is in part, what Ted says, which is his personal qualities of great integrity, great civility. I also think it is the judicial qualities of real care, thoughtfulness, asking really good questions, not debating questions, but really thoughtful questions, and trying to reach the right decision. I think in their own ways, I think every justice tries to reach the right decision. But I think that Justice Souter was particularly open-minded and particularly trying to find what the right solution was in this particular case. And I think he was widely respected by judges. And he always treated people who were arguing in front of him, even when he disagreed with them, with great respect and civility. So I think he was missed. I think he may have wanted to leave before it was too late. I think there are some people who would have wished he'd have stayed longer.
Yeah. Thank you.
I wish he'd stayed until there was a Republican
Yes,
president.
A couple of cards in here ask variations of this question. Major challenges facing the legal profession today, and relatedly, major challenges facing legal education today. Anything you'd like to speak to in terms of changes that you'd like to see professionally and with respect in particular to the legal academy?
I think one of the challenges facing the legal profession and facing legal education is how many lawyers do we need? And
this is not screwing in a light bulb joke, is it?
It is not. Well, it sort of is. But they always used to say when I was in law school that if you had one lawyer in town, which in my day you could, they would starve. But if you had 2 lawyers in town, they would both make money. So it is a profession that to some extent creates its own demand. But you have now a very large percentage of people graduating from law school, not from law schools like this, but from law schools around the country who are not getting jobs.
Right.
And I think that one of the things that we have to look at in terms of legal education is how many lawyers do we really want to be educating? And what we need to look at as a profession is how do we employ the people that are coming out of law school in a reasonable way. And I think those present challenges. I think that the incentive is when you have lots of lawyers who are unemployed is to find work for them to do, and the work is to bring more lawsuits. I think that that's not necessarily a desirable approach from a societal standpoint. And I think that we need to try to focus on how do we make sure the courthouse doors are open, how do we make sure that justice is served, but how do we also make sure that we don't become a litigation society. We're already the most litigious society in the world. And to some extent, I think that is good because we are one of the societies in the world that most protects individual rights and individual freedoms. At the same time, I think we've got to concern ourselves with the costs to society of excessive and sometimes either frivolous or very close to frivolous litigation. I think another problem that the profession has is we talked about civility with respect to Justice Souter, and we talked about civility in politics. We have a civility problem in the legal profession. Ted and I are sometimes on the same side, but sometimes on different sides. But we're always friends. We always respect each other. And when we started practicing law, I think the vast majority of the legal profession was a collegial profession. We've lost some of that. Now, some of that we've lost just because of how large the profession has become. Some of that we've lost because of how large law firms have become. But I think part of it we've lost because people have been focused on the machinery of litigation, the machinery of the law, as opposed to the practice of law. And I think that we lose something as a society, and we lose something as a profession when we lose the collegiality, we lose the civility, we lose the mutual respect that I think used to characterize this profession and needs to.
I don't have anything to add to that. I just want to make an observation that the time that I spent in law school at Berkeley was really an absolutely wonderful experience for me. I loved it from the instant that I walked into that first classroom. I thought, I cannot believe that I'm actually getting to do this. It was a very tumultuous time politically in America, the mid-'60s, and Berkeley was not the place for Republicans, but it was an absolutely wonderful intellectual experience, and I just hope that people that do go to law school have an experience like that. And David's taught in law schools and been very much closer to the education side of things than I have, but I have great respect for those of you who give the time to the students and teach them how to think and challenge them and things like that. I think it's just a fantastic experience.
Well, thanks. I've got a very serious question here. I recently read about the play Aight, the first reading of which I understand that Brad Pitt played David Boies and Martin Sheen played Ted Olson. What are your feelings about that play, and were you involved in the making of it? And I'll add to it, what do you think about the character or the actors who were cast?
Well, actually, Brad Pitt played the judge.
Oh, he did? Okay.
George Clooney played me.
Oh.
that actually was that was actually the second production in Los Angeles. In the first production in New York, Morgan Freeman played me.
I'll tell you how that came about. The judge in our case decided to have a video of the trial, and he was going to stream it to an overflow room, which did happen, and he was going to stream it to other courts in the United States so citizens could come in and watch the trial, which seemed to me a wonderful thing. Here's a constitutional question involving the rights of millions of people. It's a big, major civil rights case, a trial. We had 12 days of trial, expert witnesses on everything from political history to marriage and raising children and psychology and stigmatization and all of those things. Unbelievable education. And our opponents didn't want that to happen. What does that tell you about people who are on the other side of this issue? And I don't mean to disparage people, but why not allow the American people to see this? They said that their witnesses would be intimidated and harassed. But the witnesses that they had were people that were teaching and giving lectures and writing books, and so and it was this is America, you know, we have public trials. So anyway, I won't relitigate that, but for various different reasons, the video was stopped and it couldn't go out to the American public. So the American public never got to see this trial. So we put together a foundation when we started this case, a nonprofit foundation called the American Foundation for Equal Rights, because we needed financial support for the witnesses and the various costs. It was a very big thing. And that was Rob Reiner and Michelle Reiner, the famous people from Hollywood, and Norman Lear, and Dustin Lance Black, who's a famous screenwriter. He won an Academy Award for Milk, sat there during the whole trial. And he thought the American people need to see this. This is something that needs to be done. So he took the actual transcript of the trial, the actual language of the lawyers and the witnesses, and he condensed it into 90 minutes, and he called it Aight. And the American Foundation for Equal Rights has made that play available to communities, no charge, to colleges, universities, municipal groups. It's been all over the world now. The first reading of it, and the actors don't have to spend a lot of time. They just stand on stage and read the script, so they can start that day. You know, these people are good enough to pick it up and really get into the role, even in a short period of time. The first one was on Broadway, and John Lithgow played my role, and Morgan Freeman and Rob Reiner and so forth. And there's some funny moments during the case and some very dramatic moments during the case. And then they did it in Los Angeles when George Clooney played David, and Martin Sheen played me. Brad Pitt originally wasn't included in this thing, and about 3 weeks before the performance, Rob Reiner told me, he said, "Brad Pitt wants to be in it." I told him no. It's already filled up. And I said, "Wait a minute." Brad Pitt? So they moved. Rob Reiner went out off the thing, and the guy who was going to be the judge, who was terrific, played this witness that David dismantled during the trial. And Brad Pitt got to be the judge, and he was really great. So we allowed Brad Pitt to be the judge.
Picking up on this same question, and pointing to last night, where when tickets became available for last night's event, they sold out as fast as Springsteen would have filled out, the Capitol Center. People are thirsting for information about what happens in the judiciary and in judicial proceedings. What do you think about cameras in courtrooms generally and cameras at the Supreme Court in particular?
I generally favor cameras in the courtroom. The technology now is sufficiently sophisticated so it doesn't have to be intrusive. It's not the kind of thing that they used to worry about, that the cameras would be very distracting and the like. In those states that do have cameras in the courtroom, and there are lots of states, once the trial gets started, everybody forgets about the camera. And I think that to the extent that it causes people to have an eye on the camera, which I think does not happen very often because you just get caught up in what's happening. But to the extent it does, I think that is at least as likely to have a positive effect as a negative effect, because people know that what they're doing and their inflections and their antics, if they are engaging in them, are being caught on tape and are going to be reviewed. So I generally favor cameras in the courtroom. Now I think there are cases involving issues of privacy and the like, where you have to be careful about it. And most states have developed rules that are protective. I think in the Supreme Court, that may be one of the last places you get cameras. In some senses, I think it's one of the first places we ought to have cameras, because it is such an important decision-making body in our society. But I think the justices so prize their privacy and so prize, to some extent, just the ability to walk around Washington and not have everybody recognize them. I think it is going to be a while before they come to it, and they, after all, are the final word. They get to decide more than anybody else whether there's cameras there. And so I suspect that's going to take a while. But I think you're going to increasingly see cameras in the courtroom. There's been a trend that way for really 2 decades, and I think that'll continue.
I agree with David. One of the things, Bush versus Gore, that was the first time that the Supreme Court allowed the audio to be available immediately as soon as the argument was over, and there were 2 arguments in the Supreme Court. As soon as those arguments were over, the audio was available, was put out on NPR, C-SPAN, and so forth, and they've done that several times now with cases that have large public interest. The Bush versus Gore case, of course, was very controversial and contentious, at least as far as the politics were concerned. The fact that people were able to hear the argument, I think, made a big difference in terms of the acceptance of the American people, whether they disagreed or not with the outcome. And many, many people, of course, seriously disagreed with the outcome and seriously felt strongly that it was wrong. But They listened to the justices ask the questions. They listened to the arguments. And a lot of people told me that, oh, I didn't realize it was like that. And they were they just thought someone would go in and give a speech for an hour or whatever it was. But the fact that the justices were so engaged enhanced the respect that was given to the decision, despite its unpopularity in some quarters. And justices almost uniformly are against cameras in the courtroom. And I think I'm totally with David on this. What happens in that courtroom in the most obscure APA case or the Social Security benefits or things like this, the intellectual debate is rich, fabulous experience just to go watch it. When I was Solicitor General, I went to watch every single argument that our office was involved in, which was virtually all of them. And I got hooked, I couldn't not, it was just so fantastic. So I think they're right about their privacy, but I don't think that they are Supreme Court justices. They didn't have to take the job. They didn't. They sat there for, like in John Roberts' case, 4.5 days of confirmation hearings. Everybody knows who he is. Justice Sotomayor's got a best-selling book out and goes around on television and Oprah and whatever. So their privacy, it's our government, and people ought to see that. And it's a little surprising how vigorously they are in protecting. I'm going to get hell for this. I hope you're not going to let this camera go out. But they're so vigorous about protecting First Amendment rights every place else, except there. It should be there. The camera should be. American people should see it. And the chief judge of the New York Court of Appeals once told me, Judith Kaye, said, most of the people don't watch it, I mean, but certainly in law schools. I mean,
absolutely. This is a question for you, Mr. Olson. When did you personally decide to support the freedom to marry in the same-sex context?
Well, I'd never really been against it, except that it was an idea or a concept that is relatively new in political debate and in relationships in this country. I grew up in California. I mean, the idea that people's different sexual orientation should be an occasion to treat them differently, it just doesn't seem right to me. But when the issue became a popular issue or a very current issue with many, many people, and then the people in California, the California Supreme Court had declared that individuals had a right to get married to the person that they loved and couldn't be prevented from doing that on the basis of sexual orientation. 18,000 people flocked to get married. David talked about the time earlier when Mayor Newsom was going to let licenses get granted before this decision, and the joy in people's faces and the exuberance had to affect you emotionally. And then when the people of California, I was disappointed, being I still think sort of a Californian, did this, I was very disappointed in the people of California. So when I was contacted originally, the people that originally were thinking about bringing this case didn't think that I would be interested because I'm a conservative and therefore all conservatives this, that, and the other thing. And they contacted me and asked me, would you be interested in doing this? And I said, I have to check with my wife and a couple of my partners in my firm to make sure that we can give it the support that it deserves. But yes, I would be interested in doing it if it's going to be done right. If we have the right plaintiffs, we have the right resources, we have the right commitment to take it all the way, because this is a big deal. And I wanted someone like David. It turned out David is the perfect person in the world to be a partner with me on this, so that it wasn't conservative liberal. It was two lawyers who were recognized for other things, whether we like it or not, from opposite ends of the political spectrum. And we set out with the case to accomplish what we could in court, but also to accomplish what we could in the medium of public opinion, and to speak to as many people as we possibly could through as many forms of media attention that we could. Articles, op-ed pieces, television appearances, and so forth, so that we could help shape public opinion with this case. So it's the most important thing I've ever done as a lawyer, because you think the number of people whose lives can be affected, not just by the court decision, but by changes in public opinion that David was talking about earlier.
Mr. Boies, would you like to describe your path into this, this litigation, this case?
Ted adverted to it before, and I remember when Gavin Newsom, who was then the mayor of San Francisco, permitted the county clerk to issue marriage licenses to same-sex couples. And people lined up from all over the world to come and try to get married. And it occurred to me then, and I had not really thought about marriage at that point. I'd just sort of taken it for granted. But you saw these people who so much wanted to get married, and it just didn't seem to me that there was any reason for the government to be saying no, that you can't do that. And so when Ted called me about this case, it was one that I enthusiastically joined.
Oh, that's great. A couple of questions actually about recent comments by retired Supreme Court justices. Justice O'Connor's comments about Bush versus Gore received a lot of play. I saw that Justice Stevens said something about it yesterday. And this is far from a new phenomenon. Justice Blackmun, Justice Powell famously made comments expressing reservations, at least, about prior Supreme Court decisions. Is that, would you have any comments about that phenomenon and the effect that that has on these cases as constitutional cases?
Well, I think that it reflects the fact that everybody's human. People make mistakes, and also people change their minds. I think that people who decided the Japanese internment case, while they were still on the court, said things that recognized that that was the wrong decision. I think that it's sometimes misunderstood, I think, by the general public when a justice like, for example, Powell said, no, I got it wrong in Hardwick. But I think that it reflects his honesty, his personal courage, because it takes a certain amount of courage to say I was wrong in that. But I don't think it should be that surprising. Justice Jackson used to say about the Supreme Court that we are not final because we're infallible. We're infallible because we're final. And I think that while we give the court final power, nobody ought to believe that they are really infallible. They're human beings. They make decisions, a lot of them very good decisions, sometimes bad decisions. And when they think about it and reflect, particularly about a decision that was made as fast as Bush v. Gore was, they may think back and say, I think that was the wrong way to do it. I think people learn from that. I do not think, however, it ought to make people believe that the court is less reliable or is less entitled to respect for its judgments. I think it really ought to enhance people's respect for it, the fact that people can be reflective in that way.
I don't think it's fine. Justice Stevens I have enormous respect for Justice Stevens, both as a jurist and as a human being. What a marvelous man. Yeah. And the same with Justice O'Connor, who I've known really since she went on the court. She was on the court for 25 years. He was on the court for 34, 35 years, close to that. And they want to talk about these things, so fine, let them talk about it. That I don't think that current justices are going to be swayed one way or the other about what a former justice says. And it's kind of good for the former justices to talk about what the book that Justice Stevens wrote about 5 justices that he served, 5 chief justices, 5 chiefs, I can't remember the name of it. It's a really fascinating book, and you ought to see plenty of that. Justice O'Connor has now written another book about the court, and she goes around and she's got more energy than anybody I know in terms of going all over the world and talking about civics and so forth. She's just doing wonderful things. So of course they should, as they don't need my advice on this, obviously. They're going to do it anyway. But I think it's fine.
Yeah, but and particularly, I mean, with Justice O'Connor, I mean, what she's doing in the civics area is absolutely critical. I mean, I think one of the things that law schools need to be more involved in is trying to get civics back into secondary education. And she's been absolutely phenomenal in terms of her energy and how much work she's devoted to that.
Yeah, it's a similar question. We were talking beforehand about what a blockbuster term this is, and how many huge cases, in addition to the Prop 8 DOMA cases, we're all awaiting. Would you like to say anything about constitutional stare decisis, whether and when, in these circumstances where individual justices have second thoughts about precedents, revisiting them? Justice Scalia thinks that stare decisis should play a relatively small role in constitutional adjudication. The famous abortion case, the Casey case, of course, turned largely on a conception of stare decisis. I'd be interested in any thoughts that the two of you have about that question.
I think it's a complicated issue. Certainly, stare decisis ought to play a less dispositive role in constitutional questions because there is no other effective way to revisit them.
Right.
If the court makes a statutory interpretation question, Congress or the state legislature, depending on what's involved, can change the law. With constitutional questions, only the Supreme Court can change the law. And so I think that it's important that there be more openness to that. If stare decisis in constitutional cases had been absolute, we never would have had Brown against Board of Education. So things have to be revisited. Now, I think that the idea that they should be revisited every time that a majority changes on the Supreme Court because of a new nomination in a closely divided court, I think that is undesirable. I think that it doesn't mean cases should never be re-examined. What it means is that there has to be some substantial respect for existing precedent, or else what happens is the court becomes viewed as simply a political body in which people have a vote, and if you get 5 votes in one way, you're going to come out this way. If you get 5 votes the other way, you're going to come out another way. I think that does undermine the respect that the court has. And so I think that the principle that in constitutional cases stare decisis plays less dispositive role is right. I think the extent to which some people might go in saying, I give it relatively little weight, I think that's a mistake. I think that undermines the confidence people have in Supreme Court decisions.
Yeah,
and I think it also makes confirmation hearings much more contentious.
Right. Yeah, I neglected to contextualize the question. What I had in mind is, of course, that affirmative action is also on the Supreme Court's docket right now, and it was an issue that was addressed not too long ago by the court. So.
It's addressed not too long ago twice, in the Michigan cases and then in the Seattle-Louisville cases, and those two cases produced, or those two sets of cases produced 13 separate opinions from, so what a stare decisis. And the Michigan cases, you'll recall, the same Board of Regents program with respect to affirmative action came out one way in one part of the University of Michigan and the other way about the other part of the University of Michigan. Right. I think there's a couple of other things to say. One is that John Roberts' discussion of stare decisis in Supreme Court decisions during his confirmation hearing was a wonderful exegesis of various different considerations. He's a very smart man. He'd obviously thought about it and prepared quite well for those questions. Secondly, I think it maybe makes a little bit of a difference if the first decision was restrictive of individual rights and the second decision opens up those individuals' rights. The Supreme Court's decision in Lawrence versus Texas, which reversed Bowers versus Hardwick, which had to do with private intimate conduct between individuals, changed the decision that allowed that conduct to be criminalized to overturn that and prevent it from being criminalized and respecting. I think that court feels a little bit better. Justices feel a little bit better about maybe we know more. And same with Korematsu and Brown versus Board of Education and so forth. Going the other way might be much more difficult, and so therefore you see the justices thinking and talking about it with Roe versus Wade in a kind of a different way. In the Miranda case, the Chief Justice Rehnquist, who is very, very critical of Miranda in other cases, said it's a part of our culture, we're not changing it now. So I think those are factors that are taken into consideration. I know the justices take it very seriously because they respect the decisions of their predecessors, and as they hope that their decisions will be respected by their successors.
Yeah. There are a couple of questions about Citizens United, which you were involved in. Do you think that's, there have been a couple of occasions where some people thought that the court may take another look at Citizens United, and the court has been quite clearly telegraphing, no, that's decided.
Not this majority, I don't think. And by the way, on affirmative action, I'll come back to Citizens United, but that case was the only case argued in October. The Fisher case, the Texas affirmative action case, the only case argued in October which hasn't had a decision. So it's not gonna be easy, and there will be more than one opinion. And the only justices in the October argument session who have not written an opinion for the court are Justices Scalia and Kennedy. So maybe that tells you about who's writing the opinion and or for the court and what it might be like. Of course, it could be like the Bakke case, which started this all off as 414 and so forth and so on. But Citizens United is, they summarily reversed a Minnesota, I think it was Minnesota Supreme Court decision that sort of reversed Citizens United, and they blew it away. Now there were some dissents with respect to that, but I think this court is not going to revisit that, and I know that people feel strongly about whether or not that's correctly decided and whether there's too much money in politics and so forth. And since I argued the case, and I sort of was on the other side when I was Solicitor General and arguing that these various provisions should be upheld, and then this one came out the other way subsequently in Citizens United. I'm a firm believer in the outcome of the case. I think it was correctly decided, but other people have very, very different views about money in politics. And I think that one of the things that's difficult, no matter which side you're on this issue, is regulating political speech. Political speech, if people have something to say about issues, whether they're a corporation, they're a partnership, whether they're a big corporation, little corporation. Citizens United was a 501c whatever it was, and a non-profit ideological thing, and had 1% of its money coming from corporations, and was producing a video critical of someone who was running for the President of the United States. I mean, the argument could be made that lots of people should be able to see that video, even though 1% of the funds came from a corporation. But the idea that government, Congress, shall regulate how money is spent on seeking their defeat. Members of Congress, I've been to testified at a couple of hearings on this, they're very, very critical of people that criticize them. And they feel that there should be a lot less of that. You know?
Right. Here's an interesting question. What Supreme Court decisions have surprised you, and are you often surprised? Especially now we have so much blog coverage. I mean, as a teacher of constitutional law, SCOTUS blog is just one of the most amazing developments. It's a treasure. The minute the case is argued, you've got predictions based on body language and questions and all that.
Did you guess the Obamacare decision right?
I did. I thought they'd uphold it, but not on the grounds, certainly. I'm always wrong, though.
I think every case that goes to the Supreme Court, it goes there for a reason. There is usually a a good argument on both sides, particularly the ones that go to full argument. I've won cases 9-0 there. I've lost cases 9-0 there.
They don't always get it right.
They don't always get it right. But in both of those cases, I thought there were very substantial arguments on both sides. So I think it's hard to predict exactly how a case is going to come out. I think there are some cases like the Perry case, where I think we may have a sense of what the result will be for California, but not how they're going to get there, how broad the decision is going to be. So I think that particularly if you're trying to figure out how broad a decision is going to be, I think it's hard to be surprised because it's hard to have a very firm view of that.
Once in a while there's a change of vote so that you can watch the oral argument and then see the decision and see that somebody switched sides because they sometimes slip the proofreading, you know, so a word or two will slip in, it'll tell you what's going on there. But in one of the controversial cases this term is Section 5 of the Voting Rights Act. And the court had that same issue 4 or 5 terms ago, and if you were at the oral argument, you were sure that section was going to be held unconstitutional. That's the one that selects out certain counties or certain districts or certain states that require pre-clearance approval from the Justice Department of changes in voting districts and things like that. And at the argument, and the Chief Justice was very new, it looked like that was going to be held unconstitutional. I mean, why are we treating different states and different districts differently in different parts of the country? And then all of a sudden, the decision came down, I think it was the last day of the term, and I was there that day, and they upheld it because of some weird construction of the statute that hardly anybody had even thought about or briefed, much less briefed. But I think that he and the chief wrote that opinion, and he had some language about racial discrimination in the majority opinion that sort of signaled that he was ready to go the other way, but he didn't have the 5th vote. So he sort of punted, you know, or fouled it off. So this time, you know, it's been re-argued again. So we'll see what happens. I was surprised at the outcome. The Affordable Care Act or the Obamacare case, I thought that they were going to uphold it on the grounds that it was same as a tax. Social Security, Social Security is constitutional. Why is this not constitutional? But the government, the executive branch, had said it wasn't a tax.
Right.
And they said it wasn't a tax, it wasn't a tax, it wasn't a tax, it wasn't a tax. They got no extra votes. It passed by 1 vote in each house, I think. And if they just said, well, we're going to argue that it's a tax, you know, they may not have gotten it passed. So then when it got to all the briefs and everything, the Solicitor General hardly mentioned that. It was a small part of the brief. And in the oral argument, I think it was Justice Sotomayor, very towards the end of the oral argument, she says, General Varelli, are you going to mention the tax issue, you know? And so he did it sort of, and then when it comes out, it's the Chief Justice is basically the only vote for that, and it's a small part of the opinion, and that was so I wasn't too surprised that they went that way, but I was surprised that, you know, the configuration of the way it came out. That does happen. I'll make this brief, but I had a little group about 10, 15 years ago. We had about 5 of us that really loved the Supreme Court, and we would get together 3 times during the term of the Supreme Court, and we would each select like 6 or 8 cases each dinner, with these opulent dinners at people's homes, and then we would have to predict the outcome of that case, and we had to send in our prediction 1 minute before the oral argument so that you couldn't get any advantage. And at the end of the term, and we had a notable jurist to be the judge of who won, who had the best prediction record, and we went to the most expensive place we could find. We had elaborate dinner and wine and so forth, and the loser had to pay for the wine. And the winner didn't have to pay anything. The person that came out in the middle had to pay for dinner, which was a lot less than the wine. It was really rather surprising. We got maybe on an average 2/3 are a little bit better,
Really?
but the Supreme Court would surprise us. Now, some of the cases we had, were pretty obscure cases, and you missed some of the issues if you really hadn't been involved in the case. But one year, my friend Gordon Krovitz, who was publisher of the Wall Street Journal, at that time he was editor of the Far Eastern Economic Review, and he was in Hong Kong, and he didn't read the briefs. He didn't know what the cases were. He was sort of like throwing darts or something. He won. It's like we were talking about. I was talking to Dean Broderick about the Kentucky Derby.
Right.
You can have all the knowledge in the world. You're not going to get that right.
Great. That's great. Do we have time for one more? One more question. Bringing it back to our law school setting, last night you talked about integrity. Is that something that a lawyer, an attorney, is just born with? Or could we, as law schools, foster character traits, foster integrity in the way that we teach and prepare our students?
I don't think it's something that you're born with. I think the fostering of it is a long process. I think law schools can contribute to that. I think law schools need to contribute to that. I think the profession needs to contribute to that more than we do. But it's a process. It's partly a process of education. It's partly a process of peer pressure. It's partly a process of sanctions. But I think that we need to bring integrity back to a more central role in our profession. I think we've lost sight of the fact that an adversarial system doesn't mean that you have a system that doesn't have rules and doesn't have constraints. The adversarial system is a means to an end. It's not an end in itself. And I think that everybody needs to appreciate that integrity is central to the functioning of the system. I also think people need to understand that integrity is not only sort of good morals, it's good business. We're in the trust profession. What we sell is trust. Our clients have to trust us. Judges have to trust us. Juries have to trust us. And integrity is an essential part of trust. In the long run, integrity is the way you succeed. It is something that I think elevates the profession, elevates our society, improves the justice system. But fundamentally, integrity is a way that individual lawyers ought to behave in their own self-interest.
And as to teaching in law school, absolutely. I mean, I think you teach ethics, don't you? Yeah, I did way back in the day. I mean, I had a course in ethics, and David's right. It's part of your credibility and part of, because everything you do as a lawyer, in that someone's watching, and you do it wrong or cheap or on the sly or don't represent things fairly, someone's going to remember that, and it's going to hurt you later on. When I was, after a long, contentious confirmation process, I was finally confirmed by the razor-thin margin to be Solicitor General. I wanted to hurry up and get, before a bus ran over me or anything, I wanted to get to be Solicitor General, so we went over to the court, and one of the justices, I won't name Benedia's Chambers, to be sworn in. So I was going to get the job done. They were going to be able, I don't know if you put it on tombstones or not, but it was going to be somewhere. He was Solicitor General for at least a minute. But we went into the chambers of the justice, and it was just a couple members of my family and a couple of the people that work for the justice. And he said, I've only got one word of advice for you. Don't ever lose your credibility with this court. He said, there have been times in the past when other people who've come in here have hurt their credibility with the court. Don't ever lose your credibility with this court. So I think I would have had that in my mind anyway, but I remembered that every single thing that I did and brief an argument in the court, you can never, especially with the Supreme Court, cause them to not trust you.
No, and I think the greatest compliment a lawyer can get is the compliment that Justice Souter gave you last night when he said, "We trusted you."
Yeah, Justice Souter said to me last night, he said, we always could count on you.
That's great. Well, thank you very much. Dean Broderick is going to...
What I wanted to share with you, which I hope Mr. Olson and Mr. Boies won't mind, they both want to be adjunct professors at the law school.
He is a sly devil.
And I said, why don't you come up, try the conversation, we'll see how you're received. So I think they're both pretty eligible. Last night I went to see the Constitutionally Speaking event. I know many of you were there. And I had the same reaction this morning as I had last night, which is when I hear them and see them, I'm ever so proud to be a lawyer. It's extraordinary to listen to them. And we have 2% of the 100% most influential people in the world. And I'm still trying to be one of the 100 most influential people in the building. So it's pretty impressive. In any event, I have gifts for both of them. I'm fearful, however, although I had a seat last night, I didn't have the best vantage point. And I don't want them to think that all we do is make crystal paperweights. In New Hampshire, I'm fearful they will believe that. But Pepe Herman, who is an artisan in our state, makes these really gorgeous crystal paperweights that sit on edge. And hopefully you will take one, maybe two, I don't know, last night, and find a use for them. And any time you'd like to come back and teach a class here, we'd be happy to have you. Thank you very much. It's been an honor.
Thank you. Thank you very much. Thank you.
Thank you.